I ask that all of you now join me as I acknowledge the profound debt owed to all of us to the man I now present, our speaker, Cooley's founder, the Honorable Thomas E. Brennan.
Your diploma is a Doctor of Laws. The law is the most interdisciplinary science. It touches on everything people do, on everything that happens in life. When Judge John Fitzgerald, God rest his soul, taught the first class at Cooley, he began by writing a quotation from Chaucer on the blackboard. "The life so short, the craft so long to learn." One thing you surely understand by now is that nobody knows all the law. A lawyer is defined as a person who is learned in the law. To be a person learned in the law is to be a person who studies the law, who reads the law, who contemplates the law, discusses the law, knowing that the journey takes more than a single lifetime. Your diploma says that you are learned in the law. It says that you are a lawyer. And it is a very big, impressive, and credible document. It has the familiar Cooley logo prominently displayed, and that logo features the crown of a pillar and the Latin motto, "In corde hominem est anima legis." 40 years ago, we didn't have a logo. I walked into class one day with a couple of drawings, and I asked the students to vote on which one they would like to be the logo. And they picked out the one with the Ionic column. We bought the Masonic Temple a couple years later. It looked like a law school. It had pillars out in front. Unfortunately, they were Doric rather than Ionic columns, but we never changed the logo. I came up with the Latin motto for the school, "In corde hominem est anima legis." I told the student that it meant the spirit of the law is in the hearts of men. A couple of days later, a committee of the women students came to see me. They called themselves the CATS. It was an acronym for Cooley Action Team Sisters. And the sisters let me know that the spirit of the law is also in the hearts of women. I assured them that the Latin word hominem means mankind in the generic sense and not just the male of the species, and that got me off the hook. In truth, there is no such Latin word as hominem, but I figured since I made up the word, I was entitled to make up the definition.
Aloha, thanks again for joining us. It's my privilege and honor today. We have a very special guest, Judge Thomas Brennan, founder of Cooley Law School, founder of Friends of Article 5 Convention, also former Chief Justice of the Michigan Supreme Court. I could go on and on. Very long time advocate of the Article 5 Convention, Judge Brennan. It is truly an honor to have you here today to talk about the Article 5 Convention with us.
Well, aloha to you, Dan. It's nice to be with you, even only spiritually in Hawaii. Well, I like to say that the whole function of the book it sort of follows what Benjamin Franklin said to a lady that he met outside the convention hall back in 1787, when she asked him, Dr. Franklin, what have you given us? And he said, we've created a republic if you can keep it. And so I like to think that the function of this book that I've written, which is called the Article 5 Amendatory Constitutional Convention, is really in that vein of trying to keep the republic in the 21st century, because I believe that the founders of our nation intended to write a constitution which said what it meant and which meant what it said. And unfortunately, many people seem to think today that the Constitution doesn't really mean what it says.
When is this book going to come out?
Well, it should be out about the third week of September, so I'm hoping that it'll be on the shelves around September the 16th or 18th, thereabouts.
Great.
You hear that a lot. People in this country are sick of massive federal debt. They're sick of a Congress full of career politicians who feather their own nest, play footsie with powerful lobbyists, vote for legislation they've never read, and sell their votes to get pork barrel appropriations for their pals back home. They're sick of presidential interim appointments that duck the process of confirmation. They're sick of inconclusive, interminable wars, of presidential edicts, of socialistic bailouts, of favoritism and czars, and politics as usual. Liberals and conservatives, Republicans and Democrats, independents, libertarians, progressive, people of every political stripe and persuasion are fed up with the mess in Washington. And they're beginning to realize that you can't do away with corrupt politics just by electing a new batch of banal politicians. The internet is beginning to crackle with talk about Article 5. Of course, the John Birch Society, the ACLU, and a few other minions of the status quo are getting apoplectic, wringing their hands with worry about an Article 5 convention that somehow could abolish the Bill of Rights or fill the Constitution with crackpot, harebrained schemes and ideas. But thankfully, there are people such as you heard here this morning and you'll hear this afternoon who understand that no proposal becomes part of the Constitution without the concurrence of 38 states. 3/4 of the states have to ratify any proposed amendment that comes out of a convention, just as they have to ratify any proposal that comes from the Congress. That isn't easy to do. Constitutional amendments don't get slipped through in the middle of the night like some acts of Congress. They take a long time. They're exposed to public examination and debate, just like in 1787.
Mark Levin released a book last year that stayed on the New York Times bestseller list for a very long time. I saw the Facebook photo of his dining room table covered in books that he used for his research, like he was cramming for the bar exam. What is your view of that book that he wrote, and what did he get right? What did he get wrong in that book?
Well, first of all, he got right that there's a need for a constitutional amendment. And he proposes, I think, something like 13 amendments in the book, specific amendments that I assume he has drafted. Mr. Levin is a very smart man, very bright man. Graduated from college at the age of 19, summa cum laude. That's quite an accomplishment. And he's had quite a remarkable career as a lawyer and a commentator on political facts. His book is interesting. He goes right to these 13 amendments that he's proposing. And in my book, I've gone through the 13 amendments and I've sort of cataloged them as which ones will appeal to the left, which ones will appeal to the right, which ones will appeal to everybody, and which ones will appeal to nobody. I have a number of criticisms of what Mr. Levin has written. And I think that that's always a problem when somebody sits down at their kitchen table, at their desk, in a library, wherever they sit down, and writes a constitutional amendment out of their own head or out of their own research or whatever they do. Because I believe constitutional amendments need to be vetted by a lot of people. The Constitution should speak in the language of the people, and it should address issues in a very forthright and simple way. And they need to be designed by a substantial number of people in order to have the kind of support across the board that a constitutional amendment requires. You got to have 3/4 of the states to approve it. So any constitutional amendment has to be a consensus of the American people. And I think when, for example, he talks about the balanced budget, and he speaks in terms of the GDP and so on. Well, GDP is a statistic. That's run by the government, you know. So if you're going to ask the government to do it, you're really creating kind of a false security in a constitutional amendment, because the government will simply change the rules as far as how they describe GDP. So and there were a couple of other places where I felt that he was doing something rather simplistic and really hadn't given a kind of thought that it should have been given.
I'm not a big fan of the balanced budget amendments as they're written. I know if a lot of these amendments are brought into a convention from the left, you're going to get all kinds of opposition. But also as a progressive, I know that our country spends too much. So I would hope that even though we would oppose what's on paper, we would be able to find that middle ground and get control of our federal spending. So I don't really oppose what he's doing. It's just that, like you say, it does need to be vetted, and we need to find that consensus and middle ground on those issues. Now, as you know, I did submit a list of 42 states and their applications to Congress to get an official count as to which states have applied and which states have not applied for a convention. What is the criteria of an application that should be counted, and which should be tossed aside as nothing more than something like simple mark of letters of reprisal or just chest pounding?
Well, the Constitution doesn't give us any guidelines. It doesn't specify what an application by a state for a convention, for the call of a convention, should say. It basically says whenever 2/3 of the states request a convention, the Congress shall call a convention. Well, I take that to say that if they request a convention for any reason, at any time, that's a request for a convention. There's nothing limiting the time. There's nothing limiting the purpose for the request. There's nothing that's saying that it has to be that for a certain purpose, or that the 32 or 34 states shall all be asking for this convention for the same reason. None of that's in the Constitution. So a lot of this stuff is just superstructure of considerations that's been built in by academics and other people who've written about it and have thought about it. Say, well, really, they should be asking for the convention for the same purpose. Why? Who says that? There's nothing in the Constitution that says it has to be for the same purpose. They should all be asking at about the same time. Why? There's nothing in the Constitution that says this should all be at the same time. So these are either our restrictions or limitations that have been constructed by people who have just thought about it without necessarily consulting the Constitution, and they're adding requirements that aren't in the Constitution at all.
Right. Now, when it says that in an application that if Congress does not limit this convention to a particular subject matter, that this shall be declared null and void, are those counted too? Is Congress going to impose a criteria or agenda on this convention?
Well, I expect that if I were a judge and sitting in the case on the United States Supreme Court, and somebody was asking about these petitions for conventions, I guess I would reason in this way. I would think in this way. What is a convention? A convention is a meeting of people. It is a constituent assembly. A constitutional convention is an assembly of the citizens, of the people whose consent to be governed gives the government its authority to govern. Okay, so it's a constituent assembly. Now that constituent assembly is what we call sui juris. It's a law unto itself. It makes its own agenda. It sets its own rules. It decides what to propose, and it decides when it's finished its business and when it's going to adjourn sine die, or without another meeting. So I would say that any kind of a petition to Congress, which isn't for the purpose of having a convention in the classic sense that I've just described, is not a petition for a convention. If they say we want a convention that will only consider a balanced budget, there's no such thing as a convention that only considers a balanced budget. A convention considers whatever the convention decides to consider, if you're going to have a convention. So what they want is not a convention at all. It's a committee given the responsibility to come up with an amendment for a balanced budget. So it's not a convention in the classic sense. So I frankly say, unless they simply say, we're asking for a convention under Article 5 of the Constitution, they're really not asking for a convention under Article 5. That would be one way of understanding what these things are all about.
Yeah, I have to agree with that. I see a lot of times it seems like a contradiction to me if they're asking for a convention as described in Article 5, and then they want to, because Article 5 calls for a convention to propose amendments, but they would like to propose an amendment in this one convention. It seems like a contradiction to me that they would say it's as described in Article 5, but we want this convention to only deal with this subject. And that,
well, I think I make the point in the book that it's like asking somebody to go to a baseball game and don't cheer for the team. There's certain things you do at a baseball game that if you're going to the game, that's what everybody's going to do. Right. And so to say, or we're going to have a convention, but the convention is only going to have one item on the agenda, is like saying, what kind of a convention is that? It's not a convention at all. And so if you're going to have a convention, the convention makes its own rules, it establishes its own agenda. And if you wanted to have a convention because you wanted it to propose a balanced budget amendment, that's fine. And the convention has the power to do that. But to say you can only do this, you can only go to the baseball game, but you can only eat one hot dog and no peanuts. Well, that makes no sense.
We did ask if can Congress impose an agenda? Can the states impose an agenda then as well? You're saying that the convention is completely autonomous of either?
Yeah, absolutely. And the Congress can't do it. The states can't do it. A convention is a convention. It is a constituent assembly. And when the constituents assemble, they decide what they're going to do. And that's the nature of it. It was the nature of the convention in 1787. And incidentally, Dan, I have to jump in here with a thought which is so often misrepresented by people, and Levin was one of those who misrepresented it. He talked about claiming that the convention of 1787 in Philadelphia was a runaway convention, that they were supposed to be convened for the sole purpose of amending the Articles of Confederation, and they didn't do that. They wrote a whole new constitution. So they were a rump convention. They were a runaway convention and misbehaved.
Right.
George Washington and Alexander Hamilton and James Madison misbehaved and did what they shouldn't do. In the first place, what none of them who complain about this ever mention is the fact that the convention was not called by the Congress. The convention was called by the state of Virginia, who invited the other states to go to Philadelphia for the purpose of holding a convention. And in fact, before the Congress even issued its so-called call, there were already 6 out of the original 13 states that had agreed to send delegates to Philadelphia. So if you want to know what the purpose of that convention was, you look at the resolutions of the states that selected their delegates before Congress ever addressed the issue. Before Congress ever issued their call, there were already 6 states going there. So essentially, the purpose of the convention was the purpose that the states were going there to do, and that was not what the Congress necessarily said. The other thing was that if you read carefully what the Congress said, it didn't say they were only to amend the Articles of Confederation. The word amend is no place in the congressional resolution. The resolution talks about revising the Articles of Confederation. And revise means to rewrite, to revisit, to reconsider. And that's exactly what they did.
Wow.
Anyway, that's my
that's
speech.
very illuminating. Now, getting back to the constituent convention idea, it comes up a lot when I talk to people about Article 5. They say, well, if we did that today, it would just become a convention of the oligarchs. How do we make sure, how are we confident that these delegates are going to be elected or chosen by the people or of the people rather than the selection of state legislatures?
Well, that of course brings me up to discuss Convention USA, which is something I started about 5 or 6 years ago, and it's on the internet. And the purpose of Convention USA is to bring together patriotic Americans all over the country who are interested in having a constitutional convention and participating in it. I remember attending a meeting at Harvard that was put on by Professor Larry Lessig, and he brought in a number of people from all parts of the political spectrum, including Mark Meckler, who was then the head of the Tea Party Patriots nationally, and Sandy Levinson, who was a professor of law from University of Texas, and a certified liberal. There were a lot of liberals there. Then there were some conservatives. And one of the things that they talked about was, well, what would this convention look like? Where would we get people that could be the delegates to a convention like this? And somebody made the suggestion, well, we should just select them like we select a jury. We should put all the names in a hat and start drawing people out and say, okay, you're going to the convention. I didn't think that was a particularly good idea in the first place, because I'm not so sure that you get people who really wanted to be at a convention. But nevertheless, what we're trying to do with Convention USA is we're inviting all Americans who are interested to become delegates to the convention. And we've laid out districts throughout the country. They're not gerrymandered. They're all drawn along county lines. And the districts all have a proportion between the constituents and the delegates, somewhere between 45,000 and 55,000 people. So there's 6,166 of these delegate seats, which I call seats. And the idea is to find people all over the country who want to occupy those seats and who are willing to participate in the convention. Now, they're not necessarily all going to go to one place, but they'll be able to be on the computer and to vote on issues that are presented and discussed and debated before the convention.
Now, in Florida, where you have your other home right now, they just passed a law, and it was signed by the governor, Rick Scott over there, that they will limit a convention from the state, and that maybe that won't hold up. But they also say that they're going to select the delegate that they're going to send to a convention, and basically puppet that delegate, control what that person does. If they vote against the will of the state legislature will pull that delegate out of the convention, change the vote that they just made, and then charge that person with a third-degree felony. It would be funny if this hasn't passed already now in 5 states. Does any of this seem constitutional or even legal to threaten or puppet a delegate like this if they're free to debate?
Well, I think there again, it runs afoul of the very concept of a convention. The convention is a constituent assembly. It's an assembly of people who are or represent the constituents. They don't represent the legislature. They don't represent the politicians. They represent the people. And if they're really going to be delegates to convention, that's what they do. They represent the people. And I cannot see where anybody, a legislature or a governor or whatever, the Congress or anyone else, can dictate to them what they can do, how they can vote, what they can say, how they can behave in the convention. So, frankly, to me, it's kind of amusing that the members of the state legislatures are so paranoid about what a convention might do that they're actually trying to create criminal sanctions against the people who don't do what they want them to do. And I don't think you can have delegates to a convention who are restricted. After all, the whole idea of the convention is not just to vote on things, it's to debate, to discuss, to compromise, to interact with the other members of the convention who represent other states and other parts of the country and other points of view. So the idea of having a convention where people go in and they're locked in like robots or to vote for a specific thing without listening to the other people at the convention, without engaging in debate, without engaging in discussion and compromise, to me, it frustrates the whole idea of a convention.
Yeah, I'd be very against that. I mean, there's a whole list of ideas that are out there recently for applications from different states, but what really gets me is the small things that may not get a upswelling of support from Americans, and we need to still address those issues. And I don't think that, I've said it before, I don't think that the problem is that we might make mistakes. We know prohibition was wrong, and we corrected it soon after that. I don't think that the problem is that we might make mistakes. I think the problem is that we have a system that won't correct itself. And if we try to make those corrections, we probably will make some mistakes. But as long as we have a system that's responsive to our needs, we won't really get ourselves into that kind of situation. I hope not. I hope not, at least. Just to clarify again, one more time, is this a convention of states or is this a convention of delegates from states?
It's a convention. It's a convention of the people of the states. What they said in 1787 was, "We, the people of the United States." They didn't say, "We, the people of the United States of America," because the United States of America then was the official name of the organization defined by the Articles of Confederation. So the Articles of Confederation was a treaty among 13 independent states. It had no citizens. It had no people who were subject directly to the control of that confederation. The confederation acted upon the states. When they taxed, they had a tax. They sent the bill to the states, the state legislatures, and that was the way it was operated. So the Constitution of the United States was a gathering of the people of the states, and so it wasn't a gathering of the legislature of the states. And in like manner, an Article 5 convention would be a convention of the people of the states. The people who created the Constitution, it was the people that can amend it. And the people would have to be the ones that would propose amendments to fix it.
Now, do you think that the people, you are a former Supreme Court Chief Justice, Michigan Supreme Court. You obviously would have a loyalty to your colleagues as lawyers and judges, would you prefer to have the American people, the common people, deliberating about this, or would you rather have people that are trained and skilled to write laws do this specifically?
My book begins with the story of the Massachusetts Ratification Convention, in which I describe a debate, in effect, between two farmers. And they were debating the ratification of the United States Constitution. Neither one was a lawyer. Neither one of them was a college professor or a scholar of the law. But they were citizens, and they had read the Constitution, and they had different opinions about it, and they spoke quite eloquently about their respective positions. But that was the fact in 1787, 1788, and 1789, that the people of the United States all across the board were engaged in a debate about the Constitution. And what was said, and I can't recall the man who said it specifically, but what they said, and he was a delegate to the convention, is that the Constitution is written in the plain language of the people, and that was the intention of it. And there's no reason why farmers today, businessmen, school teachers, policemen, you name it, cannot understand what the Constitution says and recognize the meaning of amendments to the Constitution and what they should be saying and how they should be interpreted. Because I mean, the whole idea of the language is for people to be able to communicate with one another and understand what they're talking about. So I say that the Constitution should always say what it means and mean what it says.
You heard from Bill Walker this morning. He insists that the states have already asked for a convention, and he makes a strong argument that the Congress has failed to live up to its sworn duty to call an Article 5 convention. Bill Fruth, you'll hear this afternoon, and he will tell you about his efforts to persuade the legislatures of 34 states to file new petitions in Washington using identical language. Article 5 says very clearly, in plain English, that if 2/3 of the state legislatures petition for a convention, the Congress must call a convention. And I support every effort to make that happen. As you heard, I wrote about it 30 years ago, and I haven't changed my mind. But the fact is that I'm not very optimistic. Most of the problems in America today stem from the fact that the Congress, the President, and the Supreme Court have all bought into the idea that the Constitution is nothing more than a set of aspirational guidelines which gives the federal government supreme power to rule over the people of the United States. The process of amending the Constitution is political. It requires the concurrence and enthusiastic support of the people of the United States, not just some of the people, not just legislators or congressmen. Amending the Constitution requires more than a majority of the American people. It requires a supermajority. It requires what former Michigan Governor George Romney used to call substantial unanimity. It requires what George Washington called the explicit and authentic act of the whole people. In short, the Constitution doesn't get amended unless just about everybody is in favor of it. Now I ask myself, what if everybody is in favor of an amendment and Congress still refuses to propose it and still refuses to call a convention under Article 5? What then? What recourse do we the people have? In 1776, Thomas Jefferson and his cohorts declared that free men have the inalienable right to establish their government. They pledged their lives, their fortunes, and their sacred honor, and they formed a new nation. Fortunately, we don't have to do that. Fortunately for us, and for all future generations of Americans, our founding fathers gave us an amendable Constitution. And even more fortunately, the development of modern technology makes it possible for the people of the United States the people of the United States, to come together in convention, to draft, debate, and propose amendments to the Constitution in precisely the manner contemplated by the founders.
Do you feel that the states have already performed on their end? Have 2/3 of the states, from your opinion, you've taken a look at the collection of records. In fact, you were part of the effort to assemble that collection of records, and we have to definitely thank you for that. But when you took a look at the collection, when it was all put together, were you satisfied that the states have fulfilled
Well,
that threshold?
I'm satisfied that the states have all shown an interest in having a convention. But as I said before, when they try to limit the convention and protect themselves from a runaway convention, so-called, which they're all terribly afraid of, they stumble, and in effect they limit their request for a convention in such a fashion that it can be well argued, and I think probably successfully argued, that they haven't really asked for a convention at all. If they ask for a convention that will only consider a balanced budget and nothing else, then they haven't asked for what a convention really is. And so maybe with those 747 applications or petitions by the states don't amount to a hill of beans, because very few of them have actually said, look, we want a convention. We want an Article 5 convention to do whatever an Article 5 convention is supposed to do. If we were to say that, why, we get 34 of those, and there ought to be a convention. Right. But I'm not so sure that no matter how the states propose it, no matter what they say, I'm not so sure that Congress is going to call a convention, because they don't want to. How can you make a Congress do what they don't want to do? The Congress works its will. They don't have the will to do it.
What instrument would it take to get that kind of moment where we can accept the fact that this Congress will not do this, and that we have to? I mean, what do we do then? I mean, really, it's what do we do to make the action legitimate? And we don't want to get hung for assembling as a treasonous act.
Well, how can it be treasonous when our Constitution gives us the constitutional right, a peaceable assembly, to ask for redress of our grievances? I mean, that's as fundamental a First Amendment right as the freedom of religion or anything else, freedom of speech. The fact that people come together and choose to come together as citizens for whatever purpose they want to, seems to me is an absolute right, and one of those that, if it's going to be stopped by our government at the point of a gun, is an invitation to a revolution.
So that's actually very interesting. There was no First Amendment when the Constitution was originally ratified, but basically what you're saying there is there's a right of assembly, basically in Article 5 itself, and if we do assemble, we are not, because there's that new clause in the NDAA that says that anyone who is a threat to the Constitution may be labeled as an enemy combatant, and it does sound similar to the fears that the founders had, that they were going to hang separately or hang together because of the actions of the Declaration of Independence. But so we shouldn't be afraid to act independently of Congress to assemble?
Oh, I don't think so. I mean, you go back a few years, and the Rex Tugwell's people got together and wrote a whole new Constitution. Now, they had the benefit of Ford Foundation or whoever has pumped a lot of money into their effort, and they sat around for a couple of years and drafted a whole new constitution for the United States of America. As a matter of fact, they even changed the name of the country. They called it the New States of America. And they abolished the 50 states, and they just had 10 departments around the nation. Nobody referred to them as a revolutionary. They were considered crackpots maybe by a lot of people, but they weren't. Nobody called the army out to make them cease and desist from writing this Constitution. So I think any group of people that want to get together and talk about the Constitution have a perfect right to do so. And I can't imagine that the federal government would stop people from gathering together to debate and discuss and propose amendments to the Constitution. I mean, that's like telling Mark Levin he can't write his book. It's like telling me I can't write my book. I mean, people have a right to make suggestions about how to improve our nation, and to do so individually and in groups. So it's on the other hand, there's some goofy stuff in our laws today, as you point out, the National Defense Act or whatever it is, that suggests to me and suggests to a lot of people that some people in the government of the United States are thinking in terms of controlling the political activity of the people in this country, which sounds an awful lot to me like Adolf Hitler.
I would have to agree with you there. I do see a lot of manipulation, though. I mean, we do see how the two parties control who gets on the ballots, who controls the presidential debates now every 4 years, and who gets into those debates. It was said before that we will never have another Ross Perot again because the two parties are controlling those debates now. One of the factors of Article 5 that I think is very important is the fact that it would give us the opportunity to break that stranglehold on our system that the two parties have, even more than the members of Congress. Is the right to alter and abolish, or to abolish, is that rhetoric, or is that a real right?
Well, the Declaration of Independence speaks about rights that are given to us by our Creator. Whatever your religious affiliation or belief is, it seems to me that everybody has to recognize that there are certain natural rights that human beings have just by their own very nature. And the fact that we are creatures with a free will, creatures who have our own opinions and our ability to decide how we're going to spend our time or what we're going to do, what we're going to believe, it seems to me is so self-evident to everybody who is rational and reasonably intelligent, that the whole idea, the foundation of the Declaration of Independence is self-evident, and that's what they said. These rights are self-evident: life, liberty, and the pursuit of happiness. We are endowed by our Creator, and that is no law, no government creates those rights. Those rights are created in the nature of human life, and so nobody can take them away from us either. Of course, Dan, what you have to remember is that under Article 5, the ratification by the states is subject to a decision by the Congress as to whether the ratification is by the legislatures in the states or by conventions in each of the states. And in fact, of all the 27 amendments that have been adopted to the federal Constitution, only one of them was ratified by way of conventions in the states, and that was repeal of prohibition. Right. But so the Congress has a role to play in making a decision as to whether the ratification is going to be by legislatures or by conventions in the states. Now, consider this, just for a hypothetical case. Suppose a convention is called by the Congress, and suppose the convention proposes an amendment limiting congressional terms to 12 years or whatever. And then it sends that proposal to the Congress and says, okay, now send it out to the states to be ratified. and the Congress considers it, and they can't get a majority vote in both houses to send it to the legislatures or to send it to the conventions. The House of Representatives wants to send it to the legislatures. The Senate votes to send it to the conventions in the states. And they bicker back and forth. They never agree. So now, will that amendment ever be ratified? Is there any way for it to be ratified? If the Congress won't decide how it's going to be ratified, is it just going to sit there unratified, proposed properly by the convention, but never ratified because the Congress won't agree on how to have it ratified? No, so I think the fact of the matter is that Article 5 has this fatal flaw in that it has given the Congress the power, first of all, to call a convention, and secondly, to determine the method of ratification. So Alexander Hamilton was concerned about having a process to amend the Constitution that didn't involve the national government. Originally, the so-called Virginia resolutions that were presented to the Philadelphia Convention at the beginning of it had a provision in there that there ought to be a way to amend the Constitution which does not involve the federal government, the national government. And Hamilton, who was a great supporter of the federal government, he didn't want to do that. So he managed to present an amendment, and amendments ultimately were changed. So we ended up with the Article 5 the way we have it. But the way we have it, the Congress has got a stranglehold on it. The Congress has got, in effect, a veto. There's no way directly that you can amend the Constitution without the approval of the Congress. Now, so people ask me, what can you do with this convention that you're trying to create of citizens, people's convention? Okay, you can't stop them from getting together. You can't stop them from debating and passing resolutions. And you can't stop a group of citizens, however they're chosen, who've come together to be a convention. You can't stop them from proposing an amendment. I mean, after all, Mark Levin has proposed amendments. I proposed amendments. A lot of people have proposed amendments. All you got to do is have a piece of paper and write the convention, write the amendment that you want to propose. So everybody can propose amendments. So here's a convention of citizens from around the country that have proposed an amendment. What's going to happen to it? Will it ever become part of the Constitution? Well, I in the book I point out four possibilities. The first possibility is that nobody pays any attention to the resolution, the proposal by this rump convention, okay? It just goes by the wayside. That's pretty obvious that could happen. Second possibility is that the proposal, once it's been adopted by the convention, goes down to Washington, and the congressmen and the senators say, oh, that's a great idea. We're going to propose it. So they then can propose it by a 2/3 vote in both houses. And then, it's following Article 5, that can go out to the states to be ratified. Or the third possibility is that you don't have 2/3 of the votes in the House, and you don't have 2/3, or you don't have the votes in the 2/3 vote in the Senate, but you do have a majority of both the Senate and the House. So the majority of the Senate and the House calls the convention, this rump convention, it labels it as an official convention. And then it accepts the proposal coming from the convention and sends it out to the states by a mere majority of both the House and the Senate. So if you have a convention, if there is actually a convention called, it's called not by 2/3 majority of both houses, but by a simple majority of both houses. And the method of ratification is to be determined by a simple majority in both houses. So that's the third way it could happen. Now, the fourth way it could happen is simply this. The convention meets, the convention comes up with a proposal. They don't even send it to the Congress. They send it to the states. And they say to each state, here's a proposal. We want you to do two things with it. Number one, we want your legislature to ratify it. And number two, we want you to call a convention for the purpose of ratifying it by the citizens of the state. So now, you have a proposal which has been ratified in both ways, that is, by the legislature and by a convention, and that because they've done it both ways, they've eliminated the necessity of the Congress deciding which way to do it. So since it's done both ways, the Congress is now out of the ballgame because they have no say in the thing one or the other. Now, I think if that were to happen, Dan, I gotta say, you would be confronted with a constitutional crisis of the first magnitude, because you would have the states through their legislature and through conventions of each state saying, we want this amendment to be adopted to be part of our Constitution. Now, what is the Congress going to say? Oh, we're not going to do that. We don't recognize that. I think they're smart enough to know that the next election they're going to have to face these people, and so they're going to agree. But nevertheless, I confess that is a completely extrajudicial or outside of the framework of the Constitution way of doing it. But I think it could be done.
When they ratified, they ended prohibition, and they sent it through the state conventions for ratification. The only time that they ever did that. What motivated them to do that differently?
The big motivation there, as I understand it, was that the legislatures in those days were still kind of how can I put it? Stodgy. They were stodgy, and it was before the days of one man, one vote, where they tried to get the legislature to be more representative of the individual of the people. And so a lot of the legislatures were just good old boys, farmers, and so on, and they essentially were tended to be dries. They were influenced by the Women's Christian Temperance Association and the other organizations that were dry, and so the Congress in proposing the amendment to repeal prohibition recognized that if they sent it out to the state legislatures, it probably wouldn't get ratified. So in order to beat that and get around those stodgy old legislators, they said, let's have a convention in each state. Well, when the conventions were organized, where the only issue in the convention was, do you favor repeal of prohibition, all the delegates who got elected to the conventions were in favor of it. That was the whole idea. So it took them no time at all. They met for one day, and each one of them passed a resolution ratifying the amendment.
Now, I think that's very interesting. I think that the actions of Congress there, I think, speak for themselves. They wanted to ratify this, but they didn't want outside groups to influence this too much. They felt that the legislatures were too influenced by outside groups and wouldn't do what the people wanted. So they depended on a convention for the only time. I think that's amazing. I think it speaks volumes as to what the average American should expect from a convention just by their past actions. I think it's a significant move on their part.
Enjoyed our discussion, Dan.
Me too. Aloha.
Aloha. Goodbye.
We're coming together because we care about the United States. We're worried about our beloved nation. We don't think the government in Washington, D.C. is working the way Thomas Jefferson, James Madison, Alexander Hamilton, and George Washington intended it to work. It was supposed to be a federal government comprised of sovereign states exercising limited powers. It was not supposed to be in charge of everything. It was not supposed to be dictating every aspect of our lives from the cradle to the grave. The government created in Philadelphia in 1789 was not supposed to have an unwritten constitution. It didn't create a ruling class oligarchy or authorize politicians to spend the people's money to build up their own power or keep themselves in office. The founders knew that self-interest and partisanship are the enemies of liberty. They recognized that the government they designed could become corrupted by the very individuals who were elected to run it, and they provided a way for the people to react, to come together, and to fix it. They gave us a remedy, and we, the people, intend to use it. The Article 5 Convention is an amendatory convention, a way for the people to draft refine and propose individual amendments to strengthen the Constitution we already have. It's not empowered to write a new Constitution. The founders expected the Constitution they gave us to be a living document. They expected us to adopt amendments that would keep America the land of the free. When the Philadelphia Convention was finished, a lady asked Benjamin Franklin what sort of a government had been created. His answer echoes down through the years to each and every one of us. It is a republic, he said, if you can keep it. I invite you to visit www.conventionusa.org. See what we're doing there. See if you want to be part of it. In the early days of the 20th century, a progressive movement swept America. In state after state, constitutions were amended to provide new ways for the people to participate in their government. By the process of initiative and referendum, citizens were enabled to have a direct and a personal voice in framing state constitutions and laws. That was 100 years ago. This is a new millennium. This is 2010. This is the age of computers and the internet. The explicit and authentic act of the whole people no longer depends on paper petitions and big meeting halls. It is now possible to hold a convention in which every registered voter in every state of the Union can participate directly, immediately, and personally. We are no longer captives of media conglomerates who limit our choices, who dictate our agenda, and who manipulate our decisions. In Convention USA, every citizen will have a chance to speak, to be heard, to be part of the give and take of political debate, and to vote on every proposal that comes to the floor of the convention. My friends, what we're doing in Convention USA is new and exciting. It's bold. It's not a revolution, but it is revolutionary. It's going to change the whole process of politics in America. You know, I don't expect to live to see it happen. I'm 81 years old. But you young people, you law students, you will see it. You will be part of it. And someday, when millions of your fellow Americans are routinely participating in Convention USA or something like it, and the Constitution of the United States once again gives them the republic that Benjamin Franklin promised, you will be able to remember this day. And you'll be able to remember September the 16th, 2010. And you'll be able to tell your grandchildren that it all began at the Thomas M. Cooley Law School in Lansing, Michigan. And you were there. Thank you.
Promote all these amendments. Everybody's got some great ideas out there. And again, I headed into this particular situation with the blinders on of that Citizens United. And being in Occupy Wall Street has kind of shined some light on some bigger issues as well. And I kind of find myself in the position where I'd really like to see campaign financing. I would really like to see across the board lobby reform so it affects the Department of Defense also. But I can't really say that my idea or my amendment is more important than somebody else's who wants to end the bed, take care of foreclosures, start jobs, fix our trade laws in this country. So you'll see at the bottom of this map here, we've got an online petition on our website, and it's just basically calling for the states to go ahead and support this idea of a national constitutional convention and basically made the best amendment win. We can promote all kinds of them and really make some good changes in this country. We don't feel that this is the 60s happening all over again. It feels more like the 1930s or maybe even the 1770s. We have a really great chance to make some positive changes in this country that are going to really form what this country looks like for the coming years and century. And we really would like to see this happen. So that's kind of where we're at right now.